Good morning, everybody, and welcome to this webinar on strategic land and public rights of way. I'm Matthew Stimson. I'm a Principal Associate in the planning team at Shoesmiths, and I'm joined this morning by two of my colleagues, Karen Howard, who's a partner in our London office, and
morning, everyone.
Morning, Karen, and by Grace Mitchell.
Morning.
Hello, Grace, and Grace is an associate also in the planning team. So as I said, we've still got people joining at the moment, which is very, very pleased to see. Apparently we've got a record number of you that at least signed up to the webinar this morning. So we'll do our very best to make it interesting and informative. Just to let you know, I think you've probably seen from the joining instructions that the WebEx platform has a Q&A function. On the, I think there's a side panel, and you can type in questions there if you want to ask us any questions. Please feel free to write the questions throughout the webinar as they occur to you, and we'll do our best to answer them at the end of the session. Feel free also, please, to take notes of what we say, but the webinar is being recorded, and the recording and notes of the presentation will also be made available to you in the next few days. Also, we should say that if after the event there's something that you wish you'd asked but didn't think of at the time, yeah, please feel free to get in touch with us after the event. So we'll begin. I mean, by way of background, we as a planning team get involved in all stages of strategic development, planning for strategic development sites, from the initial due diligence through the purchase contracts and site promotion, planning application, and the implementation stages, of course. We've therefore seen firsthand and had to advise on the implications of dealing with public rights of way throughout all those stages of the planning process. As such, we've seen on quite a number of occasions how the existence of public rights of way, or the belief and assertion that they exist, can have a serious impact both on the planning and development of strategic land. A key reason for this, of course, and hence one of the core themes of today's presentation, is that although public rights of way are highly relevant to planning, they are subject to separate rules and procedures, both in terms of their creation and more particularly how they can be stopped up or diverted to accommodate development, which sits somewhat uncomfortably alongside the planning regime, as we will see and delve into in a bit more detail. The complications of dealing with public rights of way are obviously not exclusive to strategic land. They can arise on all types of development, but quite plainly, they are a particular risk factor for the development of large, previously undeveloped sites that may well court local opposition, and which are several years in promotion, planning and development. The aim of the webinar is therefore to consider the various types of public rights of way and how they can be factored into the planning and development of strategic land in particular. I'll begin with the first two topics, firstly looking at the various types of public rights of way and why they're important. I will then consider the relationship to planning and potential cases of conflict and how these can be managed. Grace will then introduce the options and procedures for stopping up and diverting public rights of way. And she will then hand over to Karen, who will consider how to manage objections in the consultation process, and also conclude for us by considering whether there is any case for reforming the law in this area. So, the types of public right of way and why they're important. First and foremost, public rights of way are a form of highway. It's an obvious point, but by definition, they are a route across land over which the public at large has the right to pass and repass without permission or interference. They are therefore immediately distinguishable from private rights of way or easements, which may exist for the benefit of the owners of one parcel of land over a neighbouring parcel of land, and therefore are exclusive to those individuals. They're also distinguishable from permissive rights of way, which only exist with the express permission of the owner of the land, which can obviously be withdrawn by that owner at any time. There are an estimated to be 140,000 miles of public rights of way in England and Wales, and a further 9,300 miles in Scotland. And these fall into 5 main classes, defined by the manner in which they can be used. And you may well be familiar with some of these, but it's worth reiterating. Firstly, footpaths. As the name suggests, these are for use on foot only. Distinguish these from footways, which is the technical term for the pavements that run alongside roads. So footpaths obviously are the tracks and paths across open land. Next category is bridleways, which by definition are for use on foot or on horseback, but which may also be used by cyclists, although priority on those routes must be given to the horses and pedestrians. But also interestingly, bridleways may in some cases also be used for driving animals. So beware of flocks of sheep and herds of cattle being driven along bridleways. So that may well be a factor to take into account. We've got restricted byways, which very similar to bridleways in that they can be used on foot or on horseback, and by any non-mechanically propelled vehicle, which essentially is a bicycle. I was racking my brain to think of any other non-mechanically propelled vehicle, but essentially bicycles, and also in some cases for driving animals in the same way as bridleways. You've then got the peculiar byway open to all traffic, BOAT for short, which is essentially a road, but might appear as a track, and is for use by all vehicles and other kinds of traffic, but which is used mainly by the public on foot and by horse riders. So it's a track that's occasionally used by traffic, but it is mainly used by as a footpath or bridleway. You then got cycle tracks, which we've included, which are obviously for cycles, cycles only, pedal cycles specifically, with or without a right of way on foot. So they may be exclusively for cyclists, but may also allow pedestrians to use them as well. It's worth mentioning that in certain limited cases, where a public path crosses open countryside, and I specify open countryside as opposed to agricultural fields, or is a designated coastal path, under the Countryside and Rights of Way Act 2000, there is also a right to access land either side of the path. Now, these are quite limited cases, but it's worth being aware of should you be developing a site that is crossed by a coastal path or is on open land, open countryside that isn't currently used for agriculture. Now, different types of path therefore can have quite different implications in terms of how they're used. and how they might affect development and who will be interested in what happens to them. So understanding the extent of the rights as well as the route and the width of the right can be quite critical. The starting point in many cases is the definitive map and statement of public rights of way, which are maintained by the local authority. These have existed since the National Parks and Access to Countryside Act 1949 introduced them and required them to be established and maintained by the local authority. Now the map will show the route of the path as a line on a plan, and the corresponding statement will record the extent of the rights to use the path, as well as the physical characteristics of the path where they're known. For example, its width or any features along the route and by which the route is defined. Under Section 56 of the Wildlife and Countryside Act 1981, the definitive map is conclusive evidence as to the existence of a public right of way, as well as to the route and width of the path where it's specified. So if the path is shown on the definitive map, then you can be certain that it exists. However, the map and statement is not conclusive evidence that other rights of way do not exist, i.e. the fact that a path is not shown on the definitive map does not mean that it does not exist. It is therefore necessary to undertake a thorough site survey to ascertain whether other rights exist, either over the same path or indeed other paths over the land. The local authority has a duty to keep the definitive map under review, which means updating it where evidence demonstrates the existence of new paths or that the route of a path has changed over time. New highways and new paths can be created by the presumption of 20 years continuous use. So it's possible for third parties to make applications to register new paths, or indeed to provide evidence that the route of the path has changed over time. So that is a very important takeaway point, that it's to be wary of the possibility of applications being made for new public rights of way to be registered, as well as a means of frustrating development, and also to be certain that the route of the path it's also important to be certain of the route of the path when it comes to stopping up or diversion. So obviously when you apply for stopping up order or a diversion order, as Grace will look at in more detail, you have to define the route that you're stopping up. So if there's any possibility that that route has changed over time, then that needs to be factored into the application to amend the order for the order. Now the implications of there being a footpath, a public path across a parcel of land are obviously quite clear. It is an offence to obstruct a highway, which includes a public path, and obviously an offence to build over a highway, again, which includes a public path. So developing over a public path, developing on land that is crossed by a public path could well be an offence under the Highways Act, which is enforceable by the local authority in the Magistrates' Court. Be aware also that local authorities in most cases, and also parish councils, have a power to maintain public paths under the Highways Act, which is entirely without prejudice to the duties of the Highway Authority or other parties to maintain the path. So where land is crossed by a path, it may well be that the parish council may want to come onto the land to maintain it under those powers. So in terms of promoting a site, it is worth considering whether a public rights of way is a constraint or whether it's indeed an opportunity for development. It could be either, depending on the circumstances. These are matters obviously that will need to be considered at the outset in promoting land for allocation in the local plan, as well as in more detail at the planning application stage. In terms of constraint, the existence of a public path clearly limits where development can go. On the basis that you can't build over or obstruct an existing public path, it will affect not only where buildings go on the site, but also roads and other means of access and infrastructure may need to be designed around existing paths. They are therefore a form of constraint that must be factored into determining the potential yield of a site in terms of housing numbers at the promotion stage. Paths that cannot be accommodated within the scheme may also weigh against development in the planning balance, again, both at the site promotion stage and also at the planning application stage, and quite plainly may give rise to public objections. However, a path can also be seen as an opportunity for development. A site served or crossed by a public path provides a means of access, which and can count in its favour in terms of sustainability of the site. It also provides an opportunity to enhance the benefits for the scheme and also wider benefits to the public by carrying out improvements to the public path. Consider also the opportunity to create new public paths, whether a footpath, a bridleway or a restricted bridleway, by agreement under Section 25 of the Highways Act, or by an order, again under the Highways Act. In terms of managing the risk of public paths, this could come in at the stage when you're entering into contract to buy a site, either an option or a conditional contract. So it's important to consider the existence of any public rights of way or potential public rights of way and how to deal with them at that stage. If it's clear that a public path will need to be stopped up or diverted, consider whether the contract should be made conditional upon obtaining a stopping up or diversion order. Since such an order is separate from and usually obtained after planning permission is granted, the circumstances for condition satisfaction, i.e. in the contract, confirmation of a satisfactory order being made, will need to be clearly and separately defined in the contract from any planning conditionality, because it's a separate process and requires a separate satisfaction. And consider also the time required to obtain the order. Again, it's likely to be after the grant of planning permission. So therefore, this will need to be factored into any long stop dates within the contract. In terms of dealing with potential paths, Section 31A of the Highways Act allows an owner to register a map and statement and declaration that a particular path or a particular parcel of land does not contain any public rights of way. Obviously, they can't do this for paths that are already shown on the definitive map, but in terms of preventing new public rights of way being created, this can be a useful tool. So it's worth considering at this stage whether the landowner should be required to make such an application and who should be responsible for doing that and the timescales for doing that under the contract. In addition, or alternatively, consider whether specific provision needs to be made for dealing with third-party applications that might come along, such as including in the contract a right to terminate, or extensions of time to the contract and the long stop date in the event that an application is made. Obviously, consider also who should be responsible for dealing with the application, and what assistance each party should give to the other. For example, as a developer, you may have the resources and want to maintain control of the process and any proceedings, but a landowner is likely to have the knowledge about the use of the land that will be essential to rebutting any application or dealing with the evidence that is submitted in support of the application. Turning to the planning application process, now Grace is going to consider, as I said in a moment, the procedures for stopping up in more detail, but the powers under the Planning Act are for use only where stopping up or diversion is necessary for the development of land, and it's worth stopping to consider that, because accordingly it's important to note that the planning application should be quite clear about the need to stop up or divert any paths in order to establish a clear case that it's necessary. Because if you're looking to divert or stop up a public path reliant on the fact that it's needed in order to develop the land, you have to prove that case. So if the public path wouldn't actually interfere with the development you're proposing, but you just want to move it for other means, then you may not be able to satisfy the case for having diverted under the Planning Act. However, the existence of public paths and public rights of way and their use is clearly a land use issue, which will be material to the determination of the planning application itself. Objections from local interest group are obviously going to be likely to be made at the planning application stage, as well as in relation to any stopping up or diversion orders that follow. As I say, Karen will look in this in more detail in her section, but any such objections will need to be taken into account by the local planning authority. The treatment of public rights of way in the scheme does therefore need to be properly planned and thought through. Consider well-used bridleways in particular, as consideration will need to be given to the safety of horses and their riders, as well as other road users. So delivering a bridleway alongside a planned road may not always be acceptable. Now, a public path is primarily a route from A to B. That's obvious, and it doesn't carry with it any wider legal rights of enjoyment, such as to a view or access to a particular piece of land, other than in the case of access land under the Countryside and Rights of Way Act that we looked at earlier. However, in a planning sense, regard might be had to the existence, the experience of the user, which should be factored into design. So it may well be that individuals say that they use the public path as a means to enjoy or gain access to the countryside, and this may well be a factor that's taken into account by the local planning authority in the planning decision. Another point that we wanted to consider is the phasing of development, which is also important in terms of how whether a path can be retained and when it should be retained or stopped up or diverted. On larger sites and schemes, it may well be necessary for the path to be stopped up or diverted temporarily during the construction phase, and potentially on more than one occasion. As development is carried out across the site, a path might need to be moved and diverted according to where the development is taking place. Now, under the Town and Country Planning Act, there are powers for obtaining a temporary stopping up or diversion order, but these only last up to 6 months. So if a development is going to be taking place over a longer timescale, which is highly likely on some larger sites, and also if it's going to be necessary to obtain several orders to move the path during the development phases, consider whether a temporary stopping up order would actually be sufficient. An alternative solution is to deal with it through Section 106 agreement. And this would allow you to obtain a permanent stopping up order at the outset, but through the Section 106 agreement, you could agree a system of permissive rights of way during the construction phase to ensure continuity of the public path and therefore mitigate the impact of development on the path. So through the Section 106 agreement, there'd be clauses that oblige the owner to maintain permissive rights of way during the construction phase and to agree the routes of those paths so that they could be kept open. But in terms of the public right of way itself, that would have been stopped up at the outset, and then the new path would be created at the end of the development process or the appropriate phase in the development through the dedication and creation of a new path by agreement, and this can also be dealt with in the Section 106 agreement. The final point I think to mention on the planning application process, again, is in relation to Section 106 agreements, is that they can obviously be used as a means to secure improvements to existing paths and delivering new paths. And in the usual way, this could either be by a financial contribution or as a commitment to undertake works. So again, when looking at a public footpath as an asset or as an opportunity in development, use the Section 106 agreement tool, the planning obligation tool, to offer those enhancements. So that's everything I had to say for the moment on my section. So I'm going to hand over now to Grace to delve into the details of the order process in a bit more detail.
Thanks, Matt. Do you need to hand the baton over so I can control?
Yes, there we go.
Right, I am going to do a very quick run through the main statutory powers available for stopping up and diverting a right of way. So which one you use depends on your circumstances. Section 257 of the Town and Country Planning Act enables an authority to authorise the stopping up or diversion of a right of way if it is satisfied that it's necessary to do so in order to enable development to be carried out in accordance with the planning permission. So if you've got a development with planning permission and you have a footpath going across it which you require to be diverted or stopped up, then this is the power to use. There's a couple of key points to note though here. It's a discretionary power, so it cannot be assumed that just because planning permission has been granted that a stopping up or diversion order will automatically be made. So as Matt said earlier, it needs to be done, you need to make that application to the authority very early on in the planning application process so that you are getting this underway early on in case there's any issues with using this power. It also can't be used where the development is substantially complete, and in fact we had a client who had an outline consent for a much larger development area, but works had commenced pursuant to a reserved matters approval in the area where the footpath was, and the authority decided that it had substantially completed in that instance in that area, so they could not use this power. So in that instance they had to use the Highways Act power, which I'll come on to in a moment. You can make an application to the authority for them to use this power prior to planning permission being granted, but it won't be confirmed, the order won't be confirmed until planning permission has been granted. If you can't use the Town and Country Planning Act power, the powers under the Highways Act can be used. Section 118 applies where it appears to an authority that the path can be stopped up if it wasn't needed for public use. And Section 119 allows the diversion of a path where it's shown that it's in the interest of the landowner or the occupier of the land or the public to do so, but only where the diverted route would not be substantially less convenient to the public and the diversion would not alter any point of termination of the path. So you can see that sort of the hurdles to go over for these two powers under the Highways Act are a bit higher than the one for the Town and Country Planning Act. So you should use that one, the Town and Country Planning Act, where you can. In considering whether a diverted route is substantially less convenient, the authority will look at aspects such as physical features of the new route compared to the old route, the directness of route, landscape character, any features of interest that the old route went to, and whether the new route will go to the same features of interest, any safety concerns, the needs of all users, and any potential maintenance costs. So just quickly looking at the process of making the order, there's slight differences between which powers you use, but there's also quite a lot of similarities as well. And it's also worth mentioning that local authorities also have their own different requirements on how they deal with an application. And so you should make contact with the local authority in the first instance and see what those are. They might have different requirements in regard to pre-application consultation with interested parties and what they need from you in terms of plans and whether they need to carry out a site visit and other things like that. Once you have agreed with the local authority, if they're happy with the application and they're happy to make the order, once the order is made, then they'll publish it in the local newspaper, and that notice must state the general effects of the order. It must specify a place where the order documents can be inspected and copies can be obtained, must give details of how to object and the time period to make those objections, which must be a minimum of 28 days from the date of the publication of the notice in the newspaper. That same notice must also be served on any interested parties, and it also must be displayed at either end of the footpath which is to be diverted or stopped up. And the authority will usually require the applicant that requires the stopping up or diversion to pay all costs involved, such as obviously with the notice in the newspaper. If there are no objections, or if all objections have been resolved and then withdrawn, the authority can go ahead and confirm the order. If, however, there are objections and these can't be resolved, and you're using the Highways Act powers, that the order can then be submitted to the Secretary of State for confirmation. But this is a discretionary power, they don't have to do it. If you use the power under the Town and Country Planning Act and there is an unresolved objection, the order must be submitted to the Secretary of State. And if one of those objections is from an authority, it must also then go to inquiry, which of course adds another length of time onto the whole process, usually another 12 months. So obviously that needs to be built into any development programme. Once the order is confirmed, either by the authority or the Secretary of State, you need to then carry out similar publicity requirements that was carried out at the making the order stage. So it needs to, the notice of confirmation needs to be put back in the newspaper and the interested parties must be notified. And of course, the definitive map must then be modified to reflect the changes. If a party wishes to challenge the order, it can apply to the High Court to quash the order within 6 weeks following the date the order was published, if the decision maker has acted beyond its authority or not carried out the correct procedure, so only in those instances. If the Secretary of State or authority, whoever's making the decision, decides not to confirm the order, this can only be challenged by judicial review. And just a quick note on compensation. I mentioned earlier that the applicant will usually be required to pay the authority's costs. No compensation is payable if you use the stopping up power under the Highways Act or the power under Section 257 of the Town and Country Planning Act. But it may be payable if you use the diversion power under the Highways Act, if that diversion order adversely affects either the value of an interest in the land or the enjoyment of the land, and the applicant again will be required to pay compensation. Okay, that's all from me. I'll hand over to you, Karen.
Thanks, Grace.
There you go.
Very comprehensive, and some of yours straddles some of the things that I'm about to say, so please forgive me for going over points, but it's always good to have them in mind. So I'll go forwards rather than backwards. Public path diversions and consultation principles. When I was looking at this, I just wanted to remind myself and others of those key documents that I think really help you when you are pursuing any diversions. So I've listed there the ones that I would turn to in order to help me with any part of the process, but most particularly information that would help you deal with any consultees and how to proceed with things and considering objections. So DEFRA's the latest guidance on that, which is September 2020, and it's always good to have those to hand. So Section 119 of the Highways Act empowers the Council to make an order which must be submitted to the Secretary of State for confirmation unless the order is unopposed. Firstly, where it appears to a council that's in the interest of the owner, lessee or occupier of land crossed by the path or way of the public, and it's expedient that the line of the path or way or that part of it should be diverted, whether onto land of the same or another owner, lessee or occupier. So remember that any diversion of a footpath or right-of-way must be in the interest of the applicant or the public. So those are the two things that need to be borne in mind. The diversion route must not be substantially less convenient, and the diversion must be expedient, taking factors into account, including the impact on public enjoyment. There's a recent case which people might have read, which is the Open Spaces Society and the Secretary of State for Environment. And that considered relevant factors to be taken into account when determining whether to make an order under Section 119 of the Highways Act. It was argued that the inspector at the inquiry had misinterpreted Section 119 and made a mistake by taking the benefit of the landowner into account under the expediency test. And the High Court clarified that a wide range of factors can be taken into account when considering such orders, including the landowner's interest when deciding to confirm the order. So for now, the so-called balance test, which had been recommended to inspectors, has gone to be replaced with a broader consideration of all relevant matters. I think that's really important in this time because there's no more balancing competing interests when assessing diversions. And the pendulum seems to have swung towards landowners who may want to secure diversions to protect their health and privacy. And given the times that we're living in, I can see more of those kinds of applications coming forward and obviously causing some concern, particularly for user groups. Going back to what Grace said, Section 257 of the Town and Country Planning Act enables diversion or stopping up of public footpaths and bridleways where it's necessary to enable development to take place. And when you're using this legislation, which can only be used before or in the early stages of a development, it's really important to have in mind the fact that just because you need to use 257 to enable your development to be carried out doesn't really mean that that should override interest from those consultees that need to be consulted. So the fact is that if you have a planning permission, then that may affect other people that have a right to say what they think about your proposal. So that's both on the planning side, which Matthew was explaining, but also in relation to the rights to use that path. So consultation is always very important. So when deciding to make an order, you need to consider the timing and when that diversion is actually needed. So in terms of any planning permission that you want to implement, you may want to consider at which point you actually apply for a diversion. But the one thing to bear in mind is that you must always make sure the definitive line of the existing path is currently open and is kept open at all times and available for public use. So just because you've got a development site and decide that you want to continue with your development, you can't just randomly block off paths and assume that you can get your diversion. Because if a path is inaccessible, it's likely to lead to the application for your diversion being rejected. The things that I would bear in mind is that proposals to change rights of way are a matter of trust. They're a matter of trust between any developers or landowners and also the general public. So people get very emotional about these matters, and trust me, I've seen it quite a few times. And you have to try and balance that, because you need to understand that if someone has been using a public path for many, many years and has enjoyed that, then you are dealing with something that introduces a change to them. And I remember when I first started my career, we dealt with a stopping up order in Bristol to enable a very large Lloyds Bank headquarters to be established. And the objection that we received was from a parish councillor who said, well, I've always walked right through the middle of the site and I've always had this beautiful view of the cathedral. And it is interesting that just because you want your proposals to succeed doesn't mean that you should just disregard what other people want to say about your diversion. So remember also that when you are consulting people, you're not just doing it just for the sake of it. You are consulting them to make sure that you can get your diversion. And you need to remember there's no guarantee that an order will be made, or if made, will be confirmed. So think very carefully about your strategy for pursuing that order. So who to consult? Well, once you have your draft order and plan, these need to be used to consult on the proposed diversion or extinguishment. And you need to remember that there are statutory requirements in the Highways Act to consult the district and borough council for the area. You must consult statutory undertakers. There could be way leaves or easements, things that you need to consider. And then in certain instances, you would consult, say, the British Horse Society if it's a bridle way, because they would be using it as well as other people. And in almost all cases, you would be consulting organisations such as the Ramblers and asking them to comment on the proposals. I would say in all the cases that I've dealt with, county councils are very good in their duties in relation to paths, and they do expect you to carry out a much broader consultation even at the initial stage, and that's to try to avoid objections once any formal order is actually made. Interestingly enough, under the Town and Country Planning Act, there is no requirement for any pre-consultation over the order, but I would recommend that you carry this out. So that consultation would include putting up the notices on the site which Grace mentioned and publicising the order as widely as possible. And the other thing to remember is that if anyone objects at the first stage and those objections are not resolved, they will almost certainly object to any order when it is formally advertised. So that allows you to actually engage more with those people because you know that they already have concerns about your proposed diversion. The important point is to give enough time for people to respond to you. And you need to be very clear about timescales and invite detailed comments. So in almost all instances, I would be very, very clear about the reasons and the benefits of your proposals. You need to set out in any correspondence how the proposals meet the legislative tests and are in line with the County Council's policies on stopping up and diversion. How the new route will be made up to a suitable standard, and also if any works are considered necessary, because the old route might not be as well maintained as it could be. So I would be very clear about those improvements. And details of the width of the new route and any physical features that have been agreed, such as new fencing, lighting, signage. And I would always send a copy of the plan and be very clear about what the proposals are, and an extract of the definitive map. So you're very transparent and people can understand what you are proposing to do. I think Grace mentioned site visits. I would always suggest a site visit if you can go down and meet people. I've done that several times, and really to have dialogue with them about their concerns and to understand what they are concerned about for the diversion, and what they liked about the old path that perhaps you could incorporate in the new one. So any consultation report needs to be complete and accurate. The County Council will base its decisions to proceed on this. And again, don't make any assumptions if you haven't done the proper consultation. Any objections, once they are made, would be sent to the County Council. So I would always keep very close contact with the PROW team to see what has been said. And you can have discussions with them about what's going to happen next, timing. And you could say, I'm going to engage with the various people that have objected to see whether I can put forward proposals and try and alleviate their concerns or do something a bit different so that you might be able to get their objections withdrawn. Any order can only be confirmed by the County Council if no objections to it are received, or if any are received, that they are subsequently withdrawn. And always bear in mind the order can only be confirmed if the necessary legal tests have been met. So I was considering in the summer, after a very hotly contested case, the case for reform. There are often problems with timing and the point at which a footpath or a bridleway is needed. And proposals, such as the one that I was involved with, can become stuck because of conflict introduced by separate regimes, but also conflict in your proposals, in that you might be under some deadline to get on with your development. You might have funding in place that is really important, and you might lose that funding if the development is not completed by a certain time. And all of those things, I think, come together, particularly where you've got other things that you have to do, such as footpath diversions. And so I think you need to consider that very carefully. But in the case that I've just referred to, the land was allocated for employment in 2002, and it was a very, very large regeneration scheme. And even at the time of that inquiry, there was a bridleway that we knew had to be dealt with at some point. So that was dealt with, but many years later, after a recession and all of those things and new consents were obtained, PROW applications were submitted, but they became very problematic. And there was a conflict between using the different regimes and also what was happening on the planning application side. So it wasn't just a question of actually applying for the diversion, but it was also a question of those considerations on the planning application and whether actually the footpath bridleway was actually impacting on the possible grant of planning permission for the scheme. So I think there might be a case for reform, especially to support certain cases. So particularly if you've got a large strategic site that's coming forward for much needed housing or regeneration, if you've got footpaths at that stage that you know need to be dealt with, and if they can't be incorporated as part of the scheme, which Matt was referring to, then I think you need to be thinking about what you need to do about those footpaths at an early stage. And I think that it might be a case of having regimes that are more closely aligned so that you don't end up with a conflict. I know that there is public consultation that was carried out in 2012, 2013, and there's a report which is called Improvements to the Policy and Legal Framework for Public Rights of Way. And I've been through that document, had a long read, and that contains options for improving the way that changes could be made to support planning applications and diversions. However, I don't think anything further has happened, and I have asked questions of the Planning Inspectorate, and the Rights of Way team are yet to get back to me on that. But I think there are certain things in that report that offer some useful ideas for streamlining the overall process. So I hope you can see that slide. It's very small writing, but I think that there does need to be better collaboration between highways and planning authorities, and raising awareness of the processes much earlier on a particular sort of long scheme, or a scheme that's going to take many years. I think that there ought to be more coming together at an early stage to actually talk about what paths might exist, public rights of way, bridle ways, that over time would need to be diverted. And if there was a lot more discussion up front, I think it would be less emotive going forward. I think it might be an idea to make it a requirement for any planning application involving rights of way to have early consultation with prescribed bodies. And as I was just saying, when allocating large areas for redevelopment, which may be very long term, I think if you considered making sure that all footpaths and bridleways were considered at a much earlier stage, then improvements could be talked about for a longer time, and people might get more used to the idea and actually having sort of input into the proposals, and that might end up with a better proposal overall. On planning applications, I think it would be useful for forms to ask whether there is a public right of way which is within or adjacent to the development. So again, as part of your proposals, you can be very clear about things that might impact current rights of way, and those could be dealt with at an earlier stage of the whole scheme. I do think there needs to be more cooperation between planning and rights of way officers. For example, the rights of way officers can make themselves more available to planning officers and applicants, again at an early stage, because I think that really helps, because then you understand which, you know, who thinks what about a proposal and how the improvements could benefit everyone overall. Planning and rights of way should be undertaken by the same authority. I think that that's quite contentious, and I know people wouldn't necessarily agree with that, but I do think either that or closer alignment would generally benefit the system and speed things up, because otherwise you are dealing with lots of different people, and often they have different ways of looking at things. And I think if we come together more, then actually things might happen more quickly. And I think that in some cases, the local planning authority should be empowered to consider and make decisions on rights of way without necessarily referring to the Secretary of State. And a few instances that I've been involved with, it's surprising how long everything can take once there are objections. And those delays are probably really hard on a number of people, not least of all the consultees who want certainty about what's going to happen. So the key to it really is making sure that rights of way are treated as material as part of the planning process rather than a separate regime. And the public interest aspect of any right of way should be considered early as possible. And that's really a keynote for anyone who is developing land or wanting things to change. I think the sooner that you can get the process underway, the better for all concerned. In conclusion, I'd say public rights of way are very complex, they are very emotive, and I understand it from all sides because I've promoted them and I've also objected to them. And those matters can be very difficult to resolve. So any reform in the process, I think, generally would be a good thing. And that's really all I wanted to say at the moment. Matt, I'll hand back to you.
Thank you, Karen. We started a bit late, didn't we? So we'll take a few minutes to deal with some questions that have arisen. It's nearly 11:30, so I'll forgive anybody that needs to dash off. But we did have a couple of questions that came in before we started the webinar. One relates to the legislative cutoff of 2026 for all historic public rights of way to be added to the definitive map, and after that date, obviously, new historic public rights of way cannot be added. I think I'm right in saying that that doesn't prevent new public rights of way being created by prescription, by use after that date, but in terms of finding the evidence for historic rights of way that aren't recorded, there was this proposed cutoff of 2026. As it stands, the secondary legislation needed to bring that into place hasn't been brought in, as far as we can see, and question is whether it's still likely to be brought in, or I mean, particularly the question asks whether COVID is going to have an impact. Now, what we do know is that there's been a petition against the deadline, which has had 12,000 signatories, and has obviously caught the attention, particularly of ramblers groups. So there's certainly opposition against it. My own view is it's probably at the moment going to be low down on the list of government priorities, although it does cut across two of their current priorities, of course. One is building back better, and building back to reinvigorate the economy, of which new homes is clearly an important part, but also the environmental agenda, and particularly in terms of ensuring people have access to countryside, and making sure that development supports that. So it may be one that's easier just to brush under the carpet for the moment than to avoid any opposition. So I personally can't see it coming forward anytime soon, but I've been proven wrong in the past. So I don't know if any of the other panelists have any particular thoughts on that one.
No, I think you're right, Matt. I think some of these things just take longer because they perhaps go down the priority list in terms of other things happening. And obviously we work in the planning world, and we deal with sort of housing numbers and all sorts of things, and the white paper, and the, if you like, the push for development. So perhaps this one is lower down the list of priorities, albeit that's a very important one.
We've had a couple of other questions which we might have time for. One actually is quite a succinct one. What's a typical time frame for obtaining a Section 257 order if no inquiry? And how this compares to Highway Act timeframes. Well, look, I don't know, Karen, if you want to pick this up again. My own thoughts are, unfortunately, it's not something easy to set out, and I think one of the reasons for that is that there isn't actually, whilst there are timeframes in place in terms of advertising and making objections, there's not a statutory procedure as such for applying.
No, and I think the key to it is, whilst there might be the powers that you can use, I think the thing to consider is, do you need changes as you go along the way as well? So, you know, you can have a program and say, well, actually, I like everything dealt with in 6 months, and that might be achievable, but not if, you know, not everyone is happy with your proposal, and also if things don't move quickly in terms of advertising, consulting, and all of those things. So I think 6 months is a good guide, but it could be longer. And the other thing that I've noticed is, you know, county councils that I've dealt with, you have to remember they have lots of different applications. So whilst you're keen to get your one through, they have a lot of resource issues and things like that they have to deal with. So I'd say 6 months, but don't bank on me being right on that one.
Okay, brilliant. I'm just having a quick look to see whether there's anything else we can.
I think that we were going to reply to any questions that we got subsequently, and also on the chat. So quite happy to do that. We can actually reply either individually or do it a kind of, this question was asked and this is the response.
Yeah, we could do a note after this because there's quite a few really good questions that have come through, and just send that round to any attendees.
Brilliant. All right then. Well, on that basis, and it being now 35 minutes past 11, I think we'll call it to a close there. But thank you all very much for listening. I hope it was helpful, and we'll be in touch shortly.
Thank you.
Thank you.
Thanks very much.